Massimiliano Kadar, welcome to Digital Markets Research Hub. Thank you for your availability. We know anytime we see Massimiliano Kadar, we know that the discussion will concern the tectonic reforms which are ongoing in the area of enforcement of Article 102 with the focus on exclusionary abuses. And you are in this kind of in the center of these reforms. So we will discuss the mechanics, but maybe we can start with the question about the motivation. What was the trigger for the Commission to relaunch this very detailed, nuanced, but also very impactful, potentially, and in reality, we know, consultations about the enforcement?
So first of all, good morning, Oris. It's a real pleasure for me to be here. And before I start to get into the questions, I should start with the usual caveats, which is that today I'm speaking in my personal capacity, and the views that I will express do not necessarily represent those of the European Commission of DG Comp. I should also say that given that we're going to talk about the draft Article 102 guidelines, my views are also to some extent preliminary or provisional, because I can explain what led us here to where we stand at the moment, and I can explain the thinking behind the draft guidelines. But of course, at this very stage, we are very much looking forward to the comments from stakeholders. And so by definition, the draft may be subject to change depending on the comment that we will receive. So please take everything that I say today as our views at this stage. And it doesn't mean that on the basis of the comments we receive, we may not change our views. This is really part of the process. So I'm just going to mention this at the beginning, and I will not say it again and again, but I think it's important that that this is clear from the outset. So a couple of words to follow up on your question on where we stand and what brought us here. As you will know, and as I'm sure those will follow will know, at the moment we do not have guidelines in the area of Article 102. This is, of course, a different situation compared to merger control and Article 101 when you have proper guidelines. What we have when it comes to the enforcement of Article 102 is the so-called guidance on enforcement priorities that was adopted in 2009. But that document is indeed about the way that the Commission wanted to communicate on its own enforcement priorities. It was never meant to reflect the state of the law, and it had served its purpose because at the time it was really meant to try to inject some new ideas into the reflection on how to apply Article 102 and to promote what was called and is still called an effects-based approach to Article 102. So that document was not meant to address the state of the law at the time. Since then, we had a remarkable amount of judgments. We counted 38 judgments in the past 15 years. And so now the situation is very different in terms of maturity and evolution of the case law compared to 15 years ago. And the Commission now believes that it is the right time to go out with a document that tries to consolidate and systematize the case law of the EU courts in such a way that we can present the Commission's own interpretation of the law on Article 102. And I underline here it's the Commission's own interpretation. Of course, the court is the only institution who is allowed to interpret the law, but we can try and do our best and try to present a coherent framework for the assessment of Article 102 based on what the court is telling us. And then, of course, it's going to be always up to the court to tell us if we get it right or wrong. But we think that there is a real value in this exercise because of several reasons. First of all, because the case law has developed incrementally. That is only natural. Of course, a case is brought to the judges and the judge rule on that specific case. But this has meant that over the course of the decades, we have some judgments which may seem in apparent tension between each other. And so one of the purposes of this exercise is to try to address these tensions in a way that makes sense from an economic and legal, hopefully, perspective. And by doing that, we hope that we will increase legal certainty for all types of stakeholders. Very much related to that is the idea to try and help companies to self-assess. Dominant companies, of course, who need to understand if their behavior is in line with Article 102 or not. And we hope that by making the law clearer, we try and help them in this exercise. But of course, we don't live in a world where the Commission is the only enforcer of Article 102. We have national competition authorities and courts out there, and it is equally important for them to try and have a better understanding of what is the current law on Article 102. And so we very much hope that this initiative can help them as well. And last but not least, one of the drivers of this exercise is also to promote what we call a workable effects-based approach to Article 102, which means an effects-based approach, and let me underline it, an effects-based approach, which is based on the one hand on sound economic thinking, but on the other hand, also on the need to allow and enable a robust and timely enforcement of Article 102. So all these three objectives are really underlined in this exercise, and this is what is really in the back of our mind as we go through this process.
And again, following the chronological method, you have started this project with amending the guidance paper and asking for call for evidence and receiving quite significant number of contributions from the usual stakeholders, players in the game, but also from academics. And maybe you can highlight to us the main changes to the guidance paper, to the current document, which is already it's not binding but valid, and the main takeaway from the call for evidence.
Yes, absolutely. This was what we call a two-step approach, because we thought that there was a need to communicate quickly on some parts of the guidance paper, which we thought had been, so to say, overtaken by the events, because the position of the EU courts had made clear that the approach in the guidance paper was not correct, or at the very least needed some clarifications. And because in light of our enforcement experience, we also understood that there was a better way to present certain concepts. Now, this didn't mean that those parts of the guidance paper that we changed were the only ones that we thought needed some reflection, but they were the main ones, and that intervention was really surgical to enable stakeholders to understand that our position had changed on those parts. This was something that had to be done quickly because we knew that the process of working on guidelines would have taken quite some time, because we wanted to do it well and we wanted to have a meaningful possibility for stakeholders to comment on the draft guidelines. So we thought the process of the guidelines is going to take 2 years or so at the very least. In the meantime, it would be beneficial to everyone that we communicate on how our thinking has evolved, and that's why we already changed some parts of the guidance paper while we take our time to work on the guidelines. So to say there was a short-term initiative, which was the changes in the guidance paper, and a longer-term initiative, which is the guidelines, being well understood that once the guidelines will be out, the guidance paper, as amended, of course, will be withdrawn. But it's important that I make clear that these were surgical changes, and that it doesn't mean necessarily that the Commission has not, in the meantime, gained experience on how to apply other parts of the guidance paper, which was more detailed. But of course, given the interim nature of this exercise, we couldn't think about amending, because if we had to launch a systematic review of the guidance paper, that process in itself would have taken years and years and years, and so it would have been counterproductive in terms of the urgent needs to communicate on that. So I'm not going to go through each and every change to the guidance paper, but I think it was clear that certain things there, as I said, could have been expressed in better terms. For example, the emphasis on the so-called efficient competitive test, and I'm sure we're going to have time to discuss this later on, but by many, the guidance paper was perceived as having put too much emphasis on this specific tool, as presented as perhaps the tool, the only, some would say, tool to assess price-based conduct, and we wanted to make clear that this was indeed the case, that it is an important tool for pricing-based behavior, but it is not the only instrument to show that a conduct breaches Article 102, and I'm going to say a few words later on this. In the staff working document, which was accompanying the amendments to the guidance paper, we also clarified that that test could be applied indeed to rebates, but for a specific type of rebates, and in particular exclusivity rebates, we didn't think that that test was the appropriate one. And we didn't have to change the guidance paper to say that, because our interpretation is that the guidance paper has never said that the efficient competitive test was the right test for exclusivity rebates, but due to the application by the Commission in some cases of this test, for example, in Intel, this was perceived to be the case. So we thought this is a good opportunity to make clear that the price cost test, as a efficient competitive test, is not necessarily the right tool to address exclusivity rebates. Another area which was important, or which we had intervened clearly, was the legal status and the assessment for margin squeeze and so-called constructive refusal to supply. All of these were bundled in a single category under the guidance paper, essentially under the heading of refusal to supply, and they were all subject to the Bronner criteria, so to an indispensability requirement, and we made clear through the amendments to the guidance paper that margin squeeze is a standing type of abuse and is not subject to evidence that the input is indispensable. And for constructive refusal to supply, we also made clear that this was not subject to the Bronner criterion. And again, this was a result of case law developments which made sense from a Commission perspective, and that is why we decided to communicate on this. Perhaps a word before I move on to the call for evidence. I think that stakeholders shouldn't be surprised that we are going back to the guidance paper, and that in concrete cases the assessment changes compared to what we wrote at the time in the guidance paper, because the guidance paper was meant back in 2009 to set things in motion. I have this image in my mind of a stream or a river. It was not meant to crystallize an assessment, but it was rather meant to inject an effect-based analysis in the case law on Article 102. And some of the things that were written in the guidance paper were not based on significant experience by the Commission. Think about this efficient competitive test. At the time, we never applied it to rebates cases, and certainly not in a Commission decision dealing with rebates. So there were thoughts and reflections which made sense, but which in certain cases really had to be tested on real life cases. So I don't think it is surprising is in the meantime, and thanks to our experience, we have changed our approach on some of these matters. And I think it is only healthy that we have the possibility to have a discussion on whether certain of these things make sense or not. Now, the exercise we want to do with the guidelines is a different one, because here it's not about communicating on Commission priorities, but really communicating on a Commission interpretation of the law. So we launched this initiative through a call for evidence, as you rightly mentioned, Oles. And at the time, the call for evidence essentially stated, we are going to embark into this new exercise, so please let us know what you think. We didn't consult on any text because there was no draft text at the time. It was just a preliminary consultation on the idea of guidelines. And we were very happy with the results because we have received a lot of praise and encouragement, in the sense that this initiative was considered as having the potential of clarifying the law. There was a perception that there was a need, indeed, to have similar systematization exercise. And so on this basis, we decided that indeed it was the right thing to do, to go ahead down this path. There were, of course, some comments on the substance on certain notions that needed to be clarified. For example, the notion of competition on the merits. This notion was not discussed at all in the guidance on enforcement priorities. And so this came very clearly as one of the things that the guidelines would have needed to clarify. And we have taken on board all these comments for the purposes of working on the guidelines. So while we worked on the draft that was published on the 1st of August, the submissions that were presented in response to the call for evidence were very much in the back of our mind.
And then again, following the chronology, the Commission, in its best tradition to keep the life of academics and policymakers and lawyers busy during the potential Christmas or summer breaks, has published the draft guidelines paper for people to enjoy during the August time. And it has already generated a significant amount of commentaries from people, from experts in the field. And I wanted, before asking, and it's obviously open for consultation as well, the text itself. So now you will receive supposedly much more nuanced, refined, detailed feedback. So first of all, the guidelines themselves, and maybe a few questions, and then we'll obviously ask, we'll revert to the issues of feedback. But the guidelines themselves, the draft paper, what is the most important structure and the most important elements of this document?
So first of all, on the timing of the consultation, it is true that we published the draft on the 1st of August, but it is equally true that we're giving 3 months to stakeholders to comment. So I hope that this is considered enough. It is, of course, 50-page document, so it's not a short document, and it is complex because the case law is complex, but we feel that 3 months, considering that there is month of August in between, is enough for stakeholders to comment. So I hope we will not ruin the summer for anybody. In terms of timing, another element that I should mention is that we thought it would make a lot of sense to publish and to have a consultation launched right before 3 important judgments that were delivered by the General Court and the ACJ in September, and there's another one coming in October. And of course, we had a choice to make. Either we publish before these judgments or after. And we thought that publishing before would make sense because in this way, stakeholders have a chance to read these judgments while commenting on the text. And so we can take into account both the comments based on the judgments and the judgments themselves. So this made a lot of sense from our perspective, and that was one of the reasons why we timed the publication of the draft along these lines. In terms of structure of the document and main elements, I don't think that anyone who has an interest in Article 102 will find any big surprise in the document itself. We have a section on dominance, which highlights the main elements for the assessment of both single firm and collective dominance. On collective dominance, is the first time that there is a commission document or draft guidelines, in this case, discussing it, because the guidance paper didn't have a section on collective dominance. But we thought that in this case, that it made sense to present the interpretation of the Commission of the case law on collective dominance, because that case law is out there, and because there is an interest at national level, by national competition authorities and national judges on how to apply these notions. And so we thought it made sense to present this together with the section on single firm dominance. Then on the section on abuse, there is a section 3, which is the chapter presenting the general framework for the analysis of abuse. This is a very important section because it tries really to systematize the existing case law on general principles. We hope that we had succeeded in presenting something which is accessible from a practitioner perspective, while at the same time leading to accurate outcomes in terms of what is in breach of Article 102. This section presents for the first time an extensive discussion on the notion of competition on the merits, and in particular on what it means for a conduct to depart from competition on the merits. And it also presents a discussion on the second pillar of the analysis, so the capability of a conduct to produce exclusionary effects. Then we move on in section 4, and we have assessment of specific abuses, those where a specific legal test has been outlined. And here the consequence is that if there is a specific legal test, one has to follow this legal test rather than going back to the general 2-tier test of no competition on the merits and exclusionary effects. And then there is the second part of chapter 4, which is about abuses that do not have a specific legal test, but where the application of the general principles required some clarifications and some guidance that we can find in the case law. And last but not least, section 5 is about objective justifications, so both about objective necessity and about efficiencies. And we've tried here to put together the guidance that we found from the case law and try to explain how a company can claim that the conduct was objectively justified. So in a nutshell, this is the main structure and the main content of the document, and I'll be very happy to go more into details on any of the points.
So let us have a look at some details. Let me put it in a little bit more pejorative vocabulary, if I may. That the Commission has a very long record of in being invincible in 1 or 2 cases, and now it's getting harder and harder, let's say, to continue on this impressive trajectory, so to say. And people say that because the work is getting harder, the Commission is trying, using the vocabulary of case law, trying to rephrase maybe or rewrite the existing case law through their own perspective. And again, they say maybe it's not necessarily a bad thing, but should it be open about it, or maybe it's somehow implicit. This is a minority view, but the minority is very authoritative, has very authoritative voice. Can you reflect your views on this?
Well, and I would say that the minority can also be quite vocal sometimes, and of course we hear the different views and take them all into account. But I find it a bit surprising, frankly, to read this position sometimes, because of course it is not the job of the Commission that of writing the case law. The case law is written by the EU courts, and all we can do is to try and contribute to legal certainty by putting together some draft guidelines that we hope make sense from a legal and economic perspective. But this is, of course, the Commission's interpretation of the case law. Ultimately, it's going to be up to the court to tell us if we get it right or not. But it is certainly no hidden agenda by the Commission to rewrite the case law, even if we could. Of course, we cannot. And you know, it is, as I said, quite surprising when I see these views being expressed. And there was no attempt from this side to lower anything in terms of the court, of what the court tells us that we have to prove. As I said, firstly, because we cannot do it, and it's not within the nature of things for the Commission to do it. What we have tried to do is to present things in a way that makes sense in terms of legal principles and economic principles. And of course, all of that, keep in mind the fact that in order for Article 102 to be helpful, the enforcement of Article 102 needs to be effective. Otherwise, there would be the same as not having that provision in the treaty, and of course that cannot be. Let me give you an example. I think one of the parts of the draft guidelines which has been really subject to a lot of comments in the public domain is the part on presumptions, and I'm sure that we're going to go back and discuss it in the remainder of this webinar. That part is a good example of how to strike the different interests and objectives here at stake, because presumptions are based on the case law. From our point of view, it's crystal clear that you have judgments like Unilever, Intel, Google AdSense again recently, Qualcomm predation, which are based on the existence of these presumptions. So the presumptions are there. The Commission is not coming up with new legal principles and new ideas because these presumptions are based on the case law. And at the same time, for the Commission to underline the existence of these presumptions in the draft serves the purpose of promoting an effective enforcement of Article 102.
And as a proxy, when we talk about these presumptions, we hear very popular in academic cycle, and also in the case law term competition on the merits. So can you please explain, because some people, again, they would say that it's almost tautological, that kind of reference competition on merits is kind of a deviation from normal course of competition. Can you please explain? And the draft does offer a definition of what it is. But I wanted to hear how the reasons why we need this kind of standard, and also what is inside it.
Yes, absolutely. So first of all, as we mentioned before, there was no trace in the guidance paper of this notion of conduct departing from competition on the merits. Is it because there was no trace of this notion in the case law before? I don't think so, because if you look at the case law, this term has been there from the 60s and the 70s. So it is something that has some grounding in the first case law in Article 102. And then, of course, it's a notion that came back to fashion, so to say, in more recent years. You had a number of judgments, notably Servizio Elettrico Nazionale and then Super League, who have put more emphasis on this notion of conduct departing from competition on the merits. So from our point of view, again, we go back to choices. It's not that we had a choice to take into account or disregard this notion. The notion has been developed by the case law, so we need to present it. We need to present what is our understanding of it, and we need to present it in a way that we think makes sense. And we thought that this was one of the areas where the guidelines could hopefully be helpful for stakeholders out there. So if you look at the two-tier test, which has been established by recent case law, it is clear that the existence of exclusionary effects is one element, but is indeed only one element of the two. The other leg of the assessment is that the conduct needs to depart from competition on the merits, and there are different ways in which a conduct can depart from competition on the merits. So we try to highlight three scenarios in the draft guidelines in the hope to be, again, helpful for the concrete applications of Article 102. One scenario is when the conduct can be labeled as a naked restriction, meaning when a conduct has no interest other than to exclude. In that case, of course, it is in the very nature of the conduct that it departs from competition on the merits, because it has the only interest is that to exclude. And the second scenario is a scenario where you already have an established legal test in order to conclude that a conduct is in breach of Article 102, for example, predation, margin squeeze, tying. In those cases, the fact that a conduct departs from competition on the merits is already incorporated, is already enshrined in the legal test itself. So if one applies the legal test, then you don't need to ask yourself again, does the conduct depart from competition on the merits? Because the answer is already provided by the legal test itself. And then there's the third scenario where you have to look essentially at all circumstances to assess whether a specific conduct departs from competition on the merits. In certain cases, it will be relatively easy. If a conduct is based on deceit, for example, of course, that conduct will depart from competition on the merits. I think that there shouldn't be any doubt on that. But in other cases, you will need to look at all the different features of the market. One specific tool to establish that pricing conduct departs from competition on the merits is indeed the so-called as efficient competitive test. We have clearly stated that when it comes to pricing behavior in the strict sense, so predation and margin squeeze, this is the test to show that the conduct departs from competition on the merit. So once you have established on the basis of analysis of prices and costs that an hypothetical as efficient competitor will not be able to match the pricing conduct of the dominant firm, then you have shown that the conduct departs from competition on the merits. In other cases, and notably in the case of rebates, on non-exclusivity rebates, that test is optional and can be used to show that the conduct departs from competition on the merits. I open a parenthesis here. When it comes to exclusivity rebates, you don't need that test to show that the conduct departs from competition on the merits, because there is already a presumption that those kind of rebates, once you have shown that there is exclusivity, that those rebates do depart from competition on the merits, and they are subject to a specific legal test. So because of that reason, you don't need a price cost test to show that they indeed are potentially in breach of Article 102. And I'm closing the parenthesis. So all of this, we think it can be helpful for companies. It will not provide the answer whether each and every type of conduct departs from competition on the merits, but that is normal, because I think that you need to look at a behavior in a specific context. So I understand from the comments that have been voiced in the past weeks that some people think that the draft guidelines do not provide the definitive answer to what departs from competition on the merits. And we are, of course, very happy to take on board comments and try to make it even clearer. That's definitely part of this exercise. But at the same time, of course, there is no way that we can be too prescriptive, because this is a notion which is being developed by the court and which has to be applied in specific cases. So we can try to establish some clear lines, but of course, at the end of the day, the assessment will depend on the specifics of the case.
And you started mentioning already the feedback which has been already generated on this very impactful document. Do you anticipate significant number of papers submitted to you by the end of October? And how do you plan to process them? Will you also, you mentioned already that the latest case law will be processed as well. What is the potential implications to the original draft? How significant the changes are already envisaged?
So, of course, we will have to see because for the time being, we are reading a lot of what is being published. There are articles being published on LinkedIn. There's quite a few posts here and there. And we are going around speaking at conferences and attending conferences. And my whole team is very much engaged into this because the idea is that really we want to go out there and listen. Now it is the time to read for us and to listen. And we take this exercise very, very seriously. One thing which I can definitely mention is that we would like to receive feedback from all categories of stakeholders. Of course, there are some who have a tendency to be more vocal than others, but the purpose of this exercise is for us really to hear from everyone, including academics, including SMEs, including consumer organizations, and so on and so forth. So also those who are not necessarily the most vocal, because this is an exercise which has the purpose of ensuring an effective enforcement of Article 102, and this is important, of course, for everyone. In terms of what is going to change is, of course, very difficult to say for the time being, if anything, because we don't have any kind of representative sample of the replies that we will receive. So once we'll see the written submissions, we will study them carefully, and then we will decide on what to do next. One important element to take into account is that we will also organize a stakeholder workshop in the first quarter of next year. We're now working on the final details and hopefully we'll publish the relevant information soon. And that's going to be an additional opportunity for stakeholders to submit views on the draft guidelines. And then, of course, the other element to take into account, which we mentioned already before, is the judgments, which have already been delivered by the Court of Justice and the General Court, and which will still be delivered while we work on the guidelines. And these are, of course, extremely important for us to understand if the draft accurately represented the case law or whether some adjustments will be needed.
You recently participated at an event where different stakeholders have been a conference co-organized by Yanis Lianos in Brussels, where basically representatives from civic society have been also participating. And I was wondering, it's very difficult role to be very careful with what you say, how you say, because so much is at stake, and any wrong movement or any openness to wrong kind of doing or to an interpretation of doing something wrong is already kind of penalized very harshly. On the other hand, the Commission has this duty to hear different voices and try to process them and interpret them. How difficult it is to be simultaneously very rigid to what you say, what you hear, how you interpret things, and also open to the feedback from different stakeholders who communicate using different vocabulary, urging the Commission to apply its policy vis-a-vis exclusionary abuses in a maybe more proactive fashion.
I think it's a very important point, and indeed these kind of events make you understand that sometimes perhaps the way that we communicate has become a little bit too extreme in terms of becoming slightly too cryptic for everyone to understand what we're talking about. To some extent, it is intrinsic in the refinement process that the case law went through. Of course, it was relatively easy applying certain principles which might have been out there in the 60s to say that a certain conduct was illegal, full stop. It becomes much more complex if you need to start to look at all the different features of that conduct, and if you want to go for, one could say, an extreme effects-based approach where you need to prove actual effects and you need to quantify everything. So I think there is a balance in a way to be found and in what we call indeed a workable effects-based approach, which is not only about making sure that we can prove that cases breach Article 102 as I said, to enable a robust and timely enforcement of Article 102, but also to make sure that we can communicate clearly on what we are doing. Because if the answer to everything that could potentially be perceived as being contrary to Article 102 is I will only be able to tell you that something is illegal after a 10 years investigation and after having processed tons and tons and tons of quantitative evidence, well, that I don't think it's an answer that can be very satisfactory for everyone. And it can be very easy for us to explain to the civil society out there why we have to go through this process. So I think there is a balance to be struck here between being precise in terms of and accurate in terms of targeting the right conduct with enforcement action, but on the other hand, also not to have a process and a legal test which really goes too far in terms of imposing a burden which is unrealistic, and it's very difficult to explain to people why we will need to engage into this degree of analysis. And I think that this came out quite clearly from the event that you were referring to, where some stakeholders from civil society were telling us, look, some of the things in this document are too complex. I don't understand what this is all about because it seems to be somewhat artificial and not to make much sense from a common sense perspective. So, of course, we'll also take into account these views while keeping in mind the fact that we need to be accurate still in our assessment, and we need to go after the conduct that makes sense from a competition perspective.
Okay, because the idea of this format is primarily to help students to understand these complex issues. Maybe we can, as a recommendation to students, essentially try to do this reverse engineering and to get your advice from this from the pilot cabin, essentially. How would you approach this 30+ cases where the different vocabularies used, different terminologies used often? How do you have to put them in the common denominator, or do you have to dissect them and read them separately and then construct your kind of framework? Is this framework identical between different members of your team, or do you share most of things? Is it significant disagreement within the team itself? Can you elucidate a little bit on this side of story?
So it's an excellent question, because of course it's not there's not only one way to do it, and as I said, the case law is complex. So you need to approach it being aware that you will not always find the same language, and that certain judgments do look like they are saying different. Sometimes some people say opposite things, and so when you approach this case law, you have to be aware of the fact that it's not monolithic block which goes in one direction, but rather seem to go in at least partially different direction. And that the purpose of this exercise is precisely to try and give it a structure that makes sense. Now, if I can give some advice to people that are approaching this from, for example, a student perspective, one aspect that I think is very important is to try and go beyond the words of a specific judgment. So the court, of course, will render a judgment, but the court is made of judges which may have different views in regard to a specific case. And so the specific words that are used in a judgment are not necessarily determinative of what the case law in terms of general principles should say, but are determinative of the views of the specific judgment in that in that specific case. So try to take one step back and try to make some abstraction when looking at one judgment, and in particular when you're dealing with appeals. Because preliminary rulings, I think, are more about principles, but appeals are really about the specific fact of a case. So always be mindful of that and try not to overread what is sometimes written in some specific judgments. The second advice, which I think is very important, is try to understand the history of certain notions and certain concepts, because sometimes when the case law and even the commission decisions develops and what they say in a specific case, you tend to lose sight of what is the real meaning of certain expressions and certain tools if you don't recall where they're coming from. Take, for example, we discussed it before, the efficient competitor test. That test was introduced at the time of the guidance paper only with respect to pricing behavior. And then there was no distinction at the time between test and principle, as some people would say. It was only a price cost test that was to be applied in pricing behavior. Then some people have interpreted the case law of the EU courts as creating an efficient competitor principle and as stating that you have to apply this principle to every type of conduct and so on and so forth. I'm not sure that this position is correct, but it doesn't matter what I think, but what I think is useful is whenever we read the words as efficient competitor in our judgments, try to go back to the origin of this principle, because it helps understanding where we're coming from, and it helps us guiding our mind as we go through these subtleties of a certain matter. So all of this, I think, goes back to, yes, read each and every word of a judgment, but try not to make it a mnemonic exercise where you have to remember exactly every single sentence, because if you do that, you risk losing the big picture, and then you risk getting lost.
And also, based on this very helpful pedagogical or self-learning suggestions, recommendations, maybe you can also expand it and tell how you engage with academics on continuous basis. You process their publications and reflect, etc. Maybe you have noted some do's and don'ts. Maybe academic papers have to be technical, particularly in such field where the micro nuances matter a lot, and you operate within these nuances. So how do you where is the added value? How do you see this added value of academics?
So let me start by saying that we are very, very interested in hearing what academics have to say about the draft. We have found academic submissions and positions extremely helpful throughout the process so far, and we do read articles, blog posts, and the like that are written by academics. So it is something that we're definitely very interested in. As you say, to some extent, it is in the nature of academic work that it is indeed academic, and it can go to a certain level of abstraction, and that's absolutely fine, because frankly, this is really the job of academics. At the same time, of course, what is also helpful for us is when academic papers keep some contact with the practical implications of what they recommend. So that it's not only an abstract discussion, but at least that the academic in question has a good understanding of what would be the implications of a certain line of reasoning that she or he is proposing. So that is something that, of course, makes a lot of sense. That being said, of course, as I said, the role of academics is also to do some wild thinking sometime, and even to be devil's advocate. So that is also absolutely fine, and it is part of the job description, I would say.
The role of judges and the courts is pivotal in this game, or in this endeavor, and who we are, normal mortal people, even to start thinking about or trying predicting what will be their response to the first cases based on the new or reformed approach to one or two exclusionary abuses. But my question is not about your prediction, but do you think you as an institution are you get surprised by each and every judgment? How predictable the corpus of the adjudication of cases of decisions, of rulings of the Court of Justice of the European Union is? Is it getting more predictable? Is it getting less predictable? How much volatility is in the system? Without asking your opinion whether it's good or bad, whether it's something pathological or absolutely normal incarnation of democratic process.
So look, from my personal perspective, I think that the case law is by and large coherent. There are some areas where indeed there are some judgments that seem to go in different directions. It is not pathological at all. I think it's in the nature of the system. We're trying to do what we can in trying to present an interpretation that is coherent. But of course, as I said, it's going to be up to the court to say if we get it right or not, and it's in their job description rather than in ours. So that's absolutely the case. Now, there are some outliers in terms of judgments, and the Commission has appealed those whenever it felt the need to do so. We will see if we were right or wrong, of course, and then we will take the consequences. But of course, for example, the second Intel ruling by the German court, there was one of those examples where we thought that an effects-based approach has been brought to the extreme. So we will see what the Court of Justice will say in that case, and then we will take it from there. One thing which certainly I think is important is that if one looks at the three judgments which have been delivered in the month of September by the General Court and the ACJ, yes, there may be some elements of detail which we will need to take into account for the purposes of assessing what to do with the draft guidelines, if certain things have to be better clarified or supplemented by these rulings. But by and large, the direction, from my point of view, is the same as draft guidelines. So this shows to me that the main direction of travel is one that is predictable, where we know what is likely to come from the court in terms of big principles, and indeed these three judgments confirm it because they're very much in line with what we put in the draft guidelines. So to me, this is reassuring. Then we will see if anything has to be changed, and that's in the nature of things. But in terms of big picture, I think this is a confirmation that the case law is by and large predictable in its development.
Massimiliano Kadar, thank you very much indeed for this really illuminating conversation.
Thanks a lot, Oles. It was a great pleasure.